welcome back. We may begin our next panel, and first we have Julia Kalpokienė.
Hello, everyone. It's a pleasure to be here. And I know that we are very pressed for time, so I will be very brief. So I will talk about Sustainable Development Goal 16 and AI. And just a disclaimer, many of presenters talk about the AI Act. I will not talk about the AI Act. Briefly about me, I'm a junior researcher at Vilnius University, Kavolis Transdisciplinary Research Institute. I also teach AI and technology-related subjects, and I'm a qualified lawyer, and I work with tech projects, and I'm also a policy consultant. And this paper is co-authored with Ignas Kalpokas, who has a PhD in politics, and he works as associate professor at Vilnius University in public communication department. So the presentation is kind of interdisciplinary in a sense that it combines legal and not only legal perspective, and we write quite a lot together. So those are the publications that we co-authored, and this is also based on a publication that is still forthcoming. I have to confess that it was written nearly a couple of years ago, but it's still been kind of underway, and it will be a chapter in a monograph, Artificial Intelligence and the Rule of Law, a focus on SDG 16. So let's have a look at SDG 16 and what it is. It is to promote peaceful and inclusive societies for sustainable development, provide access to justice for all, and build effective, accountable, and inclusive institutions at all levels. So it's very broad and very important one. And target 16.3 is to promote the rule of law at the national and international levels and ensure equal access to justice for all. So what we set out to do was to assess whether AI or generative AI tools and the use of such tools in the justice systems or generally can contribute to the rule of law and achieving target 16.3, and generally if they can contribute to goal number 16, and whether there are more risks or whether it would be beneficial to look how we can contribute with AI tools. And a lot has been already said in the previous presentations in the keynote. We talked a lot today already about justice system and the shortcomings of AI, so I'm not going to repeat whatever has been said. But if you look at the literature, there is a lot of hype and a lot of promise in respect to AI and what technology can do, how it can make things more efficient and help us to achieve many things, among others, probably contribute to peace, justice, and strong institutions. And of course, we cannot overlook the technological advancement, and it's important that institutions follow what technology can offer and actually adopt those technologies. But what is the reality in terms of rule of law, and what do we understand as rule of law? And we really struggle to find a universally accepted definition of rule of law. And it means different things to different scholars, it seems. But we all understand what it is, and we have a feeling. So we need to understand what law is. It has to be predictable. It has to offer legal certainty. And can we use AI to help us with that? Well, there are some issues with AI, and I will talk about some of them. And for example, there is real-time granularity. And of course, there are some scholars that just suggest that AI can offer this very unique thing where you can tailor regulation to individual needs. So for example, you could have laws specific to an individual at a very low cost, right? And very efficiently and quickly. And it may seem as a utopia for us at the moment, but some are arguing that this will be reality. And when we look at social media, for example, sometimes you can have regulations specific to certain groups based on your membership to certain groups. For example, it's not legal regulation, but if you're on Facebook and you join a group that is dedicated to fountain pens, the rules of that group prohibit you posting anything that is not related to fountain pens. And if you write anything about pencils or ball pen related matters, it's strictly forbidden and you might be kicked out of the group. So AI and the advancement of technology can offer regulation that is really tailored to every situation. However, it then doesn't provide the legal stability and predictability that we normally need, because in order to assess risks and plan, we need legal certainty. Also, there is shift in governance, and there is this shift from public to private, and a lot of private companies tend to take over some of the functions that we historically associated with public. For example, if we look at different platforms, a lot of disputes are adjudicated on the platform. A lot of rights or enjoyment of one's rights depend on the terms of service and the provision of services on certain platforms. Of course, there is recourse, or one would hope, but the initial dispute resolution might be transferred from courts or alternative dispute resolution measures to platforms themselves. Also, another risk that we looked at was technocracy over democracy, and there is risks of technocratic governance limiting human oversight. And there is research that shows that, and there was talk about this in previous presentations about reliance on AI suggestions. And at the moment, the research shows that we as humans, even if we know how technology functions, even if we know about the biases and shortcomings of any technological solution, and generative AI in particular, we still tend to over-rely on AI outputs. So there is a risk there if we have technical solutions offering, suggesting certain decisions, for example, as in justice system or in courts, then there is this risk that it will be easier for the human judge or human deciding on something to go with a suggestion rather than arguing against that. And also, it is we see a risk if there is technology employed in the justice system. It risks blurring the line and not ensuring separation of powers, which we see as a key part of rule of law. And also, any generative AI, as we heard already, depends on data, and it's like predicting what is going to happen next. So there is this move and datification generally, and move from citizens to data points. And this may transform how justice would be accessed if we rely on technological solutions too much. But also, with AI and predictions, we can only predict, or the result depends on whatever data we have, whatever information is gathered, and whatever references or inferences are drawn from that. You know, you have to be able to measure input, but it's never, it's not the same as with what we understand as humans. So the simple example, you probably have your smartwatches, and a smartwatch kind of calculates your daily steps as you live, based on how you move and what you do. But of course, the watch doesn't really know how many steps you've made. So it predicts the number of steps based on certain movements. And anecdotally, whenever there are step challenges, sometimes people tend to kind of watch a film or do something and move their hand, arm, wrist, and it adds on the step count. And it could happen with anything else there, because it's not measuring the actual number of steps, but something that, but a certain input, and it can be faked. So similar things could happen with other things, because it's not always that we can measure the input, and it's not directly the thing that we actually want to have results on. And then if we look at explainability, and it was touched upon already as well, that you have the explainer and the explainee, and what is understandable to one, the other person may not understand that. And also, it seems that transparency actually places unrealistic burdens on those developing solutions and on those using AI technology. And we just recently, data was published that only 4.6% of businesses in Lithuania say that they use AI solutions. But it's always interesting to look, how do you ask the question, and what do people understand or perceive as AI? And we increasingly use more and more AI-based tools. And sometimes we may underestimate how much it has permeated our daily lives. So we argued that datification, artificial intelligence, and the rule of law is actually a tale of incompatible values, and it's better not to automate justice if we want. That's the last slide. Anyway, I've been interrupted, so let's keep in touch and continue this discussion. And thank you very much.
Thank you very much for this interesting presentation. This was Julia Kolpokienė from Vytautas Magnus University. And the following speaker, Tahora Hidari from University of Helsinki, will make a presentation about development risk defense in PLD and new PLD and its impacts on AI products. I'm sorry if I mispronounced your name.
No, it's fine. Yeah, it was correct. Okay, hello everyone. This is Tahora Hidari, and I'm doctoral researcher at University of Helsinki, Legal Tech Lab. So the topic of my presentation is a review of the Product Liability Directive and the proposal for a directive of liability for defectiveness products. But actually on Thursday, I think last Thursday, the new product liability published, but this slide is based on the adopted text on March, but the content of the published new directive and the adopted text is completely the same.
Maybe let's switch it to full screen. Maybe it would be more convenient.
So my main research question is about review the development risk defense in the new product liability directive and examining its applicability to AI product. So first I address several controversial shortcomings in old PLD and then applicability of DRD to those traditional products, and then following the discussions on the application of development risk defense to the traditional products, the challenge of applying the DRD to AI-assisted products will be reviewed. The Product Liability Directive, many of you must know that it's a directive which is enacted on 1985 for harmonization of rules for compensation for injured consumers by defective products. So the main reason behind the directive was to create a harmonized regime for compensating victims across the EU and consumer protection. So I try to just go faster because we are short in time, so I skip some parts. So it's, okay, DRD is Article 7 in old PLD and Article 11 in the new PLD, which is a defense which is provided for producers to remove liability from themselves in case that they cause injury, but under some circumstances, they can remove liability from themselves. Okay. So development risk defense, or DRD, in the new product liability has not changed significantly, like except few small changes, which is not related to the presentation, this presentation. So the main question is that, considering the expanded scope of the products covered by the new PLD, including software and AI-assisted products, because in old PLD, AI products were and software were not clearly covered by the PLD, but in new PLD, they are considered products. So I would discuss that if the DRD is still suitable defense for producer to avoid liability. I consider this question like specifically by discussing the challenges that was already in place in the old DRD, also apply to traditional products. So the provisions of the DRD is that the producer shall not be liable if the state of scientific and technical knowledge at the time when they put the product into circulation was not such as to enable the existence of the defect to be discovered. So two ambiguities are here. One is the level of scientific knowledge, and then the discoverability of defects. Okay, it's unclear under the old PLD that to what extent producer should take action and to what extent the producer has obligation to discover a defect. So a wording of the DRD, as you see, it's not very clear in this issue. And it doesn't, in the wording of the DRD, it's not clear that if obligation of producer to discover a defect is based on the whole level of science in the world or any field of science, or only there's an obligation that the producer should, for example, find knowledge in relevant field of science of that product. There is a very well-known case between UK and European Commission, I think it's 1989, which was about implementing of the DRD into the UK National Consumer Protection Act, which clarified this issue to some extent. So in that case, the court, the ACJ, in its interpretation of DRD, emphasized that the knowledge required for a producer to discover a defect must first be accessible to the producer and relevant to the product safety. Although the PLD does not explicitly mention the accessibility and relevance, but by this interpretation by court, then we can conclude that the main objective behind the DRD is that the producer should discover defects which are in relevant field of knowledge and accessible to the producer. There was? Okay, I also have an example about this challenge when we are going to apply to AI products. So one issue is that the borderline of different science fields to determine the relevancy of field of science would be more complex in AI products. So an example I provided is a medical diagnosis, such an AI system that analyzes medical scans to identify disease, and if, for example, it malfunctions, it can create serious damage to consumer or to a patient. So in that case, a producer could avoid liability by applying DRD and arguing that it was out of the scope of the producer knowledge, and even it was out of the relevant field of science of the producer. So this is an argument that the borderline between different science when it comes to AI products, because different field of science involved, would be more complex than even traditional products. Another controversial issues that about DRD is the presence of risk with unknown preventive measures. This usually happens like in production line or mass production, which when in quality control of production, where a producer may be aware of a potential risk, but there is not enough or sufficient knowledge or technology to prevent it. So producer in this situation knows there's a risk and a risk exists, but the preventive measures are not well developed or do not exist to remove that risk. So in this situation, so the question is that we expect that the producer foresee and prevent a risk. So also there is a famous case about this, which invoked explosion. It's about explosion of a bottle, glass bottle, in hands of consumer, and it's made some damage to consumer. The producer argued that the defect was undetectable and invoked DRD, claiming that 100% detection in mass production is not possible. So the producer argued that I couldn't recognize the risk and couldn't avoid it. But however, court rejected this argument and ruled in favor of the plaintiff. The court stated that defect could have been discovered if an additional, for example, individual inspection of the bottle on the production line had taken place. So insufficient, and also like following argument of the court, it was insufficient preventive measure does not mean that the defectiveness in the risk was unknown. So the court argued that the risk is predictable and discoverable, although the preventive measures were not sufficient to prevent the risk. Therefore, DRD cannot apply to known risk even when there is not enough preventive measures to prevent those risks. So I think that in AI systems with known risk but unknown preventive measures, this can happen maybe with new devices like more frequently, because there would be many situations where preventive measures for risk associated with AI system remain unknown. For example, for risk emerging from AI products and considering the lack of appropriate measures to prevent them, then the liability burden on producer under the new PLD could be substantial and huge. So, and it can even may lead to demotivation of the producers or developers of software or AI products if they have such a high liability burden on them. One example that I provided here is about self-driving cars or autonomous cars, which a widely recognized risk about these cars is that the failure of AI system to properly react to rare driving scenarios, such as unexpected pedestrian behaviors or unusual road conditions or complex urban environments. These risks, although these risks are well known and understood within the field of autonomous vehicle development, but there are still maybe not like clear preventive measures, because the technology to fully predict and manage all potential scenarios is still evolving and it's not complete yet. So always there should be some situation that it's not predictable by the like software or automated systems embedded in those cars. So in this situation, while the risk is known, fully preventing it with current AI and sensor technology remains challenging. And there may not be yet comprehensive solution to ensure perfect safety in all driving situations. And I don't know if I have time for conclusion. I have, okay. So as I said, the development risk defense is a safeguard to balance interest and risk inherited in the high technological products, bringing ambiguities and challenges regarding application of the 1985 directive. And new PLD also include DRD in its provision. However, despite the introduced changes in the definition of products and damages under the NPLD, the wording of DRD has not changed, except actually one difference in the wording of DRD is concept of control, which is about the time that you put the product into the market and the time that you, in new PLD, the time, the relevant time is that about as long as you have control over product, not when you put the product into circulation. Because there are some products which, after even you put them in the market, still you have control over them, like autonomous cars or softwares or this stuff. So, like smart home devices, machine learning algorithms are designed to learn and adapt based on new data. This means that risk associated with them can change as they evolve. So evolution of AI products can lead to unforeseen consequences and risks that were not discovered at the time of their release. Thank you. And if you have any question or any feedback, I really appreciate if you approach me after here. Yes, thanks.
Thank you very much. As usual, we'll have a discussion after all the presentations. And next, I'd like to welcome Julia Teriuhana from the University of Latvia about deep fakes in election.
Okay, hello everyone. Thank you for having me. My name is Julia Teriuhana. I'm from the University of Latvia and I'm also a practicing technology lawyer. And my aim today is to tell you more about regulating deepfakes in election campaigning in Latvia, since so many countries this year are having local elections. Also in Lithuania, you just have had the elections. This topic could be relevant. Probably all of you have heard what and have also seen what are the deepfakes, and now we have the official definition in the AI Act. And in brief words, these are manipulated images, audio, or text. Image, audio, video, which resembles existing persons or events and which can be mistaken or falsely appear as being real. And of course, they can be used peacefully, for example, for enhancing some user experience in museums, but also they are more and more used in the pre-election campaigns. And here you see two serious examples, like Donald Trump being arrested in this deepfake photograph, like manipulated, AI manipulated photograph, and the second one is deepfake with the President Zelensky, who declares that Ukraine surrenders in the war, which is not true and which can lead actually to very serious consequences in real life. And this fact was also realized by the Latvian Bureau of Prevention of Corruption and Combat of Corruption, which is also one of the institutions which oversees the procedure of pre-election campaign. And this was because of the fact that at the end of the previous year, in Slovakia's parliamentary elections, there has been an actual situation when audio deepfake leaked, or was intentionally leaked to the society just before the elections, like very short time before the decision day, stating that leader of the Progressive Party is trying to buy votes from the some part of Roma, like Roma society. And this, at least how the media claims, it impacted the outcome of this election in Slovakia. And also as a result of it, the party which supports pro-Russian views came to won the election and came to power. And as we are sharing the border with Russia, and we are the region where we can feel this impact, this was the intention of the Latvian government, very much supported by Latvian president, who used his legislative power and actually supplied project of these new norms. As the result, they implemented first of all, one norm in the criminal law, and later on, just 3 weeks from now, in the middle of September, they adopted the second norm to the criminal law. We will take a look a little bit later. But for now, the AI Act, even if it's now finally adopted, it doesn't really solve the problem. Article 50 has certain transparency requirements, but it doesn't really say anything about this malicious use of AI output, which is like manipulated by AI means. Yes, it says that if there is AI-generated text, audio, video, which is targeted towards public, the public needs to be notified. And this is it. It doesn't solve the problem itself. In Latvia so far, we didn't have any penalties for spreading fake news. It was and has been a very hot topic since the pandemic, since the vaccinations, and all the false news spread around this topic. But it never has been solved. And we didn't have so far any administrative law or criminal law penalties for spreading false news. In case where false news being spread, individuals could use this law on the press and other mass media, for example, if something is being published in media or online in these media outlets, and request to revoke this information or submit a civil claim to the court and claim some moral damages, as well as of course, we can use Digital Services Act as a basis and request those large platforms notify, flag the articles, and request to take down the false information. However, it doesn't really solve the problem when the information spreads. Oh, wow, what is this? That's interesting. There should be text. Okay, let me check. Deepfake. Okay, then I will just tell you what I remember, because there is a text from the law. There should be. Never mind. This spring, this initiative was launched, and in early February, the draft text was submitted, and in very speedy procedure, by the end of May, the norm providing criminal liability for spreading false news, specifically in the pre-election campaign, which is 120 days before the election, and on the election day was adopted.
Sorry, microphone.
Yes, sorry. And it provides a criminal penalty up to 5 years imprisonment, which is quite a large amount of time, and other alternatives as monetary fines or some public services, for example. But this is not all. The second one was... Yes, probably, thank you. The second one, which was just adopted in September, provides criminal liability for intentional spreading of deepfakes, not only during the pre-election period, but also during the period of selection of those state officials, which are typically approved by the Parliament Saima For example, ombudsman, prosecutor general, judges, these are all people who apply for this position and then later on are being approved by the parliament. And if somebody spreads deepfakes of those people presenting misinformation, then they also can receive this penalty, again, the same duration, up to 5 years imprisonment. And we are close to the end, thank you. And there are challenges, and there are some kind of dilemmas, which I will be happy to discuss at the coffee with you. There is an interesting situation now that criminal law provides criminal liability for defamation of natural persons. If somebody spreads false news about me, then this person can serve up to 3 months only. If somebody spreads wrong information about politicians or state officials, candidates to these positions, then they can serve up to 5 years. And what else is interesting that defamation is like from the perspective of systemic approach. Defamation is in that section of criminal law which says offenses against individual, but all these logically are offenses against state, much more serious. They are considered like offenses being against state. And from practical perspective, you can imagine if somebody spreads some deepfakes in WhatsApp, in TikTok, they can be re-uploaded, spread very fast, and you will never actually find out who is this first one who have initially uploaded this information, or it requires very much effort and very much actually investigation involved, which practically can be a big challenge. And therefore, the intention is very good to prevent the society from this disruption of elections, from disinformation. However, from practical perspective, there are challenges and there is potential imbalance if we look at the penalty for this offense. Thank you.
Thank you very much, Julia. You're probably fitted into your time frame the best of all presenters. Unfortunately. Interesting topic. By the way, the strengthened code on the practice of disinformation might be also of relevance here. But we'll have a discussion, perhaps then we'll be able. So next, I'd like to welcome a PhD candidate from our university Faculty of Law, Monika Šukytė. You will also have issues with the slides, perhaps.
Yes, hello. Good afternoon. I'm sorry, this will be a bit of modern art. It wasn't supposed to be like this, but it is what it is. So I am a PhD student. My name is Monika. My dissertation topic concerns facial recognition technologies and human rights in the European Union. And I'm very grateful to have the opportunity to share part of this research today. And today's topic is bias in facial recognition technologies. Similarly to any AI-related topic, viewing facial recognition technologies from the legal perspective requires also some practical and even technical context. Relevant technical context can be found in European legislation such as the GDPR and the AI Act. To quickly define what is facial recognition technologies, we may just look at the term itself. The GDPR has long ago established that facial images contain biometric, therefore sensitive data, personal data, which is protected in a higher degree, higher standard. The facial recognition technologies may be used for various purposes, depending on the objective of such use. whether it be to identify a person, to verify a person's identity, or to categorize such data. All of that can be done thanks to advancements in today's AI and AI functions such as computer vision and machine learning. The advantages of facial recognition technologies are being recognized both by private businesses and public authorities worldwide. However, the limitations of these tools are particularly visible and concerning in the context of law enforcement. One infamous example of harmful facial recognition use when deployed by public authorities is the case of a US citizen named Mr. Robert Williams. When a robbery took place in the city of Detroit, the police authorities ran the blurry, poorly lit image from CCTV footage of the suspect through a face recognition system. The match that came up was Mr. Williams, a man that had nothing to do with the crime. Despite the obvious lack of justification, Robert was arrested and spent the night in jail. He then sued the police department, the detective who signed off on his arrest, and the city of Detroit. There has been a settlement since then. However, what I want to emphasize is that what started with a faulty and wrong artificial intelligence result and a system that is not correct ultimately led to an arrest of an innocent person who the official deemed similar to the suspect. As argued by Mr. Roberts himself, the system could not distinguish two people of color. What was even more concerning, in my opinion, is that the officials didn't even bother trying to detect differences either. Algorithmic bias, or more specifically facial recognition technology bias, is a complex issue which can be examined not only through the technical perspective, which we might often presume, but also through the social perspective. Firstly, I want to quickly define the cause of such bias, then move on to real-life consequences, and ultimately to possible solutions, which in this case are located in legal regulation. The narrative surrounding AI used to involve terms as objectivity and neutrality. Researchers studying this topic have since challenged this belief. For example, research done by Joy Buolamwini, who is considered to be a pioneer in this specific research field. It was proven wrong since then. Facial recognition systems specifically are proven to significantly misidentify, for example, women of color as opposed to white males. However, the problem is not purely technical. As a Lithuanian researcher and my colleague, Dr. Agne Limante, has described in her works, the issue of algorithmic bias can be viewed from two separate perspectives. One is the data perspective, one is the social perspective. The data perspective concerns the quality of the images, the variety of the images, and maybe there are biased or correlations and biased decisions from which then the algorithm learns and produces biased results. There is also the inexplicability problem. However, the social perspective refers to how the technology is deployed and used in practice. For example, prejudice, lack of training, lack of human oversight combine, reinforce, and continue exacerbate those faulty results provided by the faulty data. Finally, the question which concerns the social perspective and is most relevant in my research is what is the role of legal regulation in this context, and should it play a big role? So legislators, in my opinion, should without a doubt react to algorithmic bias risks. That's because, firstly, it is not a purely technical problem. And secondly, because it leads to actual real-life discrimination prohibited under European Union law. Facial recognition systems can be discriminatory not only in terms of race, but in terms of age, disabilities, sex, or ethnicity as well. Algorithmic discrimination then transforms into discriminatory behaviors, practices, and policies within the law enforcement institutions. When combined with predictive policing, which is basically an AI system that can predict, it said so, it can predict recidivism or victimization. When combined with that, facial recognition technology can not only lead to wrongful arrests, can lead to targeting of vulnerable groups and racial profiling, and the bias can lead to real-life discrimination, as I have presented with the first case example. Also, historical patterns of discrimination are not only continued but reinforced on a large scale. And this time, the challenge that the legal system faces is not only in the digital format, but is also algorithm-powered. Algorithmic bias is not a new research topic within the research community. However, only until recently, it hasn't gone recognized in EU law. The harmful effect of bias in facial recognition technologies is now recognized and repeatedly emphasized, for example, in the recitals of the AI Act. Face recognition is mostly deemed a high-risk system of AI. Seeking to mitigate those risks associated with AI and including bias and discrimination, the Act establishes several requirements for the various actors involved in this AI deployment, use, and training processes. These requirements, for the purpose of my presentation, can actually be connected to the perspectives I spoke of before, the data perspective and the social perspective. So data quality, variety, process trackability, explainability, and accuracy are to be ensured in the whole life cycle of these systems. Also, in the social domain, people must provide, deployers and other actors must provide human oversight. There must be AI literacy for the actors involved and risk management systems. Despite these seemingly strict requirements, it can be found in the research literature the words scarce, insufficient, and not enough to protect human rights, and including the right to non-discrimination. When examining the AI Act, most researchers noticed that in case of facial recognition exemptions, multiple exemptions and very wide exemptions are being made in purpose of law enforcement authorities and their mission. For example, they do not have to abide to the requirement to have two human beings overlook the facial recognition system result, so they can bypass the requirement. There's also certain exceptions to what transparency level and what human oversight and risk management law enforcement authorities must provide. And that is only a part of those issues, and it raises the question whether these countermeasures to AI bias are sufficient, but the question of whether the AI Act will live up to its potential and live up to the expectations of becoming the next GDPR, but in a practical sense, but in terms of AI, for now remains open, as does the question of whether it is fit enough to tackle these complex human rights issues. Thank you.
Thank you, Monica. And now I'd like to invite the final speaker of our panel, Justinas Linkevičius from the Institute of International Relations and Political Sciences towards agentic security.
Thanks a lot for having me. So I come more from political science, and my background is in critical security studies, so I will provide a bit of different perspective of the conversation here. Yeah, maybe less legal, more of interpretation of how can we discuss AI and different elements of that. And my paper also refers to the EU policy on AI, but it's not focused only on AI Act. It takes a bit broader perspective of the process that the policy has been constructed from 2018 up until now. Yeah? And I also understand that I'm the only barrier between you and coffee, so I'll try to be brief as well. So thanks for that timer. This presentation is the overview of my paper, which is under presentation, and which is a part of my PhD, hopefully to be defended next year. So looking forward to that as well. I start with human-technology interaction and mainly the discussions that are going on regarding lethal autonomous weapon systems, yeah, and the different concepts over there about meaningful human control, human in, on, out the loop, and what does that actually mean. And this discussion suggests that there is something concerning over there, yeah, related to human role, and that automating or increasingly more autonomous technology might challenge human in its role, its position, yeah, in that interaction. And so it signals some kind of security concerns, but then when it comes to AI policy and this kind of different concepts as ethics, human centrism, safety, that it's already in the title, they also suggest certain concerns related to human, but it's very difficult to say what they actually mean, especially when it comes to EU policy placed as a case of the single market. And the white paper, the AI Act, explicitly says that the military element is excluded from the policy scope, yeah? Some kind of supposing that no security concerns are involved in AI-related policies. However, these discussions, how ethics should be transformed or how it should be translated into certain actions, they already suggest that also this human-technology interaction is perceived as concerning. Yeah? There are some kind of issues or there are some kind of triggers over there that needs to be regulated. What's specific in the case of EU, that it doesn't, as I mentioned, it doesn't employ the language of security, but it employs the language of risks that we already heard there from previous presentations. And then the question is what those risks mean, and are they different from security perception, even if it's not the language of the military, it's not the language of the battlefield. So the aim, the goal of my paper is to see what is the security perception in case of the emerging EU AI policy, not only in terms of the military, but in a broader sense, and focusing on this human-technology interaction and how it is developed and described. So those who know the policy, you probably recognize that pyramid, which is taken also from the web page of the Commission, like creating these different categories of risks, and we already heard that there are unacceptable, high risk, and so on and so on. And then the question is how these categories are established, yeah? Who decides which AI use and application will go to high risk, which will go to unacceptable or other risks. Because taking this as a perspective, as a policy framework, the question is, can we apply this pattern to other policies, yeah, other policy fields? Is it somehow specific to AI? And what drives that definition of those different policy categories? And I take the notion of riskification over here. Maybe you know this theory of securitization. That security issue is described by calling something a threat to security. For example, in our case, we would say, that Russia is, for example, a threat to Lithuania, and then taking extraordinary measures to address that threat. For example, increasing defense spending, buying weaponry, and so on and so on. The EU doesn't do that in terms of AI policy, but it employs the concept of risk, yeah? Something as less security or something as less urgent. And then I want to analyze and see what is that and how it relates to security. And I follow this logic of riskification and ask these questions. So what is this referent object? Yeah? What needs to be protected or safeguarded? What are those causes of risk? What is defined as harmful in case of AI? Then what is the policy response proposed? And then finally, how the EU brings that framework in its international ambitions. Because yeah, there is some kind of a discussion that we are moving into competition in terms of AI. So what I did, I took different documents from 2018 to 2024 to do a discourse analysis, and then I also did some semi-structured expert interviews with people involved in AI policymaking in different EU institutions. So you can see, okay, it's also a little bit more than art. So you can see a bit of answers what's there. So a referent object of that, it's mainly called as fundamental rights, that risks are defined in a way there is a potential harm to fundamental rights. But then the question is how that potential harm is measured, because we anticipate the future of the technology. We don't know what kind of applications will be used over there. Yeah? Then those conditions of possibility of harm appear directly related to increasingly autonomous technology, again presuming that it will be more autonomous or even receive autonomy as such. What the EU proposes as the policy measure, so we see there's some kind of framework of doing a risk assessment, setting up institutions like AI Office and so on, which are supposed to monitor how the policy is implemented. But again, it's based on very highly normative terms, yeah? As already mentioned, the human centrism, human in the loop, and so on. And what the EU also wants to do, the EU also wants to take these kind of different interpretations of AI and risks, and also transfer that on the international stage by saying that we want to have a global discussion and set certain standards, which again would be based on human centrism, human in the loop, and so on. So what I take from this, I propose that it is mainly about agentic security. What the EU tries to do, what does that mean? That this human agency needs to be safeguarded in terms of the technology, that the technology is othered, and then we need to safeguard human in the current term, yeah, in very anthropocentric views. What's interesting here that there is some kind of pretense to have universal approach, universal explanation of what human is, and that human needs to be protected against the technology. But what the discourse suggests, that this approach is very Eurocentric, that in a way it is important and relevant as long as it is concerned with European citizens. And especially we have a lot of different examples of how the EU differently treats people, for example, migrants on the border who are tracked or managed by technology as well, which is different from this idealistic view that the EU suggests. And why it is a bit difficult and complicated with this discussion and approach in the EU terms, that it demonstrates that human is put in the hierarchy, and there is no conversation of how technology will change human-technology interaction. It's like safeguarding human pre-technology rather than having a discussion how it transforms and how it translates into some kind of new realities. So coming to the concluding remarks, this question, risk over security. So I say that it's put in a deliberate way, that the EU inscribes security concerns which are not about military, but which is about human role, but demonstrating that putting the notion of risk, it also allows the EU to claim positionality internationally by saying that we have some kind of a framework that works, that we can establish in a policy way. And there is no maybe tension between, I don't know, China, the US, the EU, and so on, by saying that this is security and this is something in terms of national interest. Yeah? But about the EU itself. In a way, it's about building a fortress, and it closely relates to the EU's idea to have this digital sovereignty, meaning that the EU wants to control the conversation, not only the technology as such, but also to have a conversation, certain standards and certain principles, which put the EU as some kind of subjective actor on the international stage as well. And what is also important here that even though security in terms of AI is very much still concentrated on lethal autonomous weapon systems, what I also try to say and what I also try to argue that it's no longer about only the battlefield and the military, it's also about perceiving technology and how it is framed in terms of our reality. And that is human-technology interaction. It's much more problematic in a broader sense, what we already heard about, for example, facial recognition, rather than only the battlefield. So that would be it. Thanks a lot, and happy to talk over the coffee.
Thank you, Stinas. Does anybody have any questions or remarks? No, everybody wants to go to the coffee break. I have questions, but I'm afraid they might be too difficult, too complicated to burden the presenters. One of the main questions I have is who might be benefited by AI? Is there a tendency that it might have functions which would be beneficial to their creators? I even tested this out. I asked ChatGPT whether are there any grounds, for example, to split Microsoft into two companies. I asked Google Gemini about splitting the Google, and it provided some grounds. So it's hard to tell, but we'll see in the further research. So no remarks? Okay, thank you very much. We might proceed to the coffee break and see you soon. Čia dažnai išsikraipo jos ir kai turkai darė, Mkicas turi tą problemą. Reikia jam kažką iš anksto pasakyti. Šičia, ne? Trečia. Ne, palauk, čia 17 dienos.